Hello, I'm Payal Chawla and welcome to my podcast Navigating Commercial Disputes, brought to you in partnership with Bar and Bench. In this podcast, I aim to break down complex commercial legal issues for lawyers, law students, and legal enthusiasts alike. On June 3rd, 2024, the Procurement Policy Division of the Ministry of Finance, Department of Expenditure issued an Office Memorandum introducing new guidelines for domestic public procurement contracts. The memorandum advocates for a combination of mediation and litigation while discouraging arbitration as a method of alternate dispute resolution for disputes exceeding 10 crores. Consequently, once the current pipeline of arbitration cases dries out, future contracts are likely to rely on litigation within the traditional court system, thereby further straining an already overburdened legal system. This decision will have far reaching negative consequences for private litigants, including both individuals and corporations, as well as for India's ease of doing business ranking, foreign direct investment, and the overall legal system. Those familiar with arbitration will recall that the core objective of the landmark 2015 amendments was to ensure the swift and effective resolution of disputes with minimal judicial intervention. Ironically, this memorandum will have the exact opposite effect. The memorandum cites poor quality and corruption amongst arbitrators as the reason for the shift to mediation and court litigation. But are Indian arbitrators truly substandard and corrupt? Or is this just a perception? Are we sending mixed messages on the matter? On the one hand, we seek to promote India as a global arbitration hub, praising the high caliber talent that we have. And yet, on the other hand, we criticize our own arbitrators. How can we expect the international community to buy into this contrary narrative and bring their arbitrations to India? Is the real issue that some parties are unwilling to pay for quality legal services, which are often opposed by highly skilled and therefore highly paid legal teams? Today, I have a very special guest with me, the eminent jurist, Mr. Justice Madan Lokur. He was a former judge of the Supreme Court of India and is currently serving as a judge with the Supreme Court of Fiji. In conversation with Justice Lokur, I aim to discuss some of these questions and hope to explore the ramifications of this policy shift, what it means for arbitration in India, its effect on the legal system, and how it could alter the landscape for disputes and businesses operating in the country, both domestic and foreign. Welcome, sir. I'm so honored to have you on the show.
Yeah, thank you.
So I want to begin by asking you your thoughts on the memorandum first.
Well, I think the whole idea is a little retrograde, in the sense that, first of all, it's not even evidence based, in the sense that there is no evidence on record or anywhere to suggest that, arbitrators are not, impartial. There is no evidence to suggest that, it's very expensive. And what really is the idea behind the memorandum? I've not been able to understand. On the one hand, the government is trying to encourage arbitration, and then they come out with this thing which says that anything above 10 crores, if the claim is above 10 crores, then there's no arbitration on that. You have to go to the court. So really, I've not been able to understand why they have come out with this memorandum.
So I absolutely agree with you that the entire evidence is only anecdotal.
Yeah.
And it's the perspective of the government in a sense. So, but do you think that this is an issue of miscommunication between departments, or it's actually somewhat thought through? Because, like you've correctly said, there is a contradiction. On the one hand, we say we want to make India into an arbitration hub, and we want to encourage arbitration, reduce the load from the court. And then there is a memorandum from a department of the government that's actually discouraging arbitration.
Yeah. I think this appears to have been thought through, in the sense that I've just come across information that one of the PSUs has already acted upon this memorandum.
Oh, really?
Yeah, yeah. If that is correct, if my information is correct, and I have no reason to disbelieve it, then it's not something, a sort of a miscommunication. If it was, then probably this PSU would not have, said that. Now, that PSU, by the way, it appears, is going a little further. They want to amend the existing contracts to say that if your claim is going to be more than 10 crores, then you'll have to file a suit. So it's not only the future contracts, but apparently they want to amend existing contracts as well.
So this is very disheartening.
Yeah.
So it's uh, what can we expect? Other departments to follow suit?
Yeah, I would imagine they would. I mean, if this is the trend, this may be just a one-off sort of a PSU, but yeah, it's an indication that others might follow.
And this is outside the current ministry.
Yes, 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 it's
I
outside.
see.
I think it's one of these oil ministries or one of these petroleum ministries, one of these kind of ministries.
So, in fact, what we're talking about is perhaps, let's say, an oil and gas dispute or a construction dispute,
Yeah, something like that.
which could
Yeah,
have heavy evidence to lead, and we're actually thinking about going to the courts
yeah,
in
yeah,
this.
yeah.
So the memorandum mentions that one of the reasons that government could be losing arbitrations is because of the transferable nature of the jobs that government officers have, and there is no continuity. Do you think that this is an issue? Because personally, I don't see it as an issue because of the higher levels of attrition in private companies as well.
Yes, I mean, I agree with you. It can't be, even if it's a reason, it's not a good reason. What is the guarantee that if, a civil suit is filed, for example, that the officer will not be transferred, right? So if the civil suit goes on for maybe 3 years, 4 years, 5 years, there are bound to be transfers. So it's not that the government loses arbitrations or gets an award against it only because an officer is transferred. That's one thing. The second thing is, where is the evidence? That the government has been losing in arbitrations only because officers have been transferred.
Transferred,
There's
right?
no evidence of this.
So, but what the government is saying is that ultimately it's public money, they're accountable to the public, and therefore perhaps court litigation is a better form of uh,
In
litigating disputes.
Yeah, in what way? Because you're looking at speed. An arbitration will enable the parties to resolve a dispute much faster than a court.
Yes.
Okay, so if you're looking at that, fine. If you're looking at informality as one of the aspects where you're not bound by the strict rules of evidence and so on, arbitration is the way.
Yes.
So in what way does arbitration take second place as against litigation? And if it does, why has the government so far been encouraging arbitration? So
So there is clearly a dichotomy there.
yeah,
But is it, and do you think there is some argument to be made? Arbitrations, the lawyers charge, the fees is higher, and the arbitrators are charging fees because court ultimately is free. Not
yeah,
really because there's court fees,
yeah,
but if you would
yeah.
let
In
that
that
go in
sense,
that sense, but
yeah, yeah, you're right. But let me tell you from my personal experience, it's not that the arbitrators charge a huge amount. Perhaps they do, but my experience has been that the lawyers charge more than the arbitrators.
right.
All right. And what I find surprising is that lawyers who are appearing for PSUs charge more than what a private company or an organization is paying.
So, but I don't see that as a bad thing, assuming, because I've heard different things, but assuming, and this is very good and heartening news, that PSUs are now paying more than private parties. And I don't necessarily see that as a bad
No,
thing
it's not. Yeah.
because, and also, the concise nature of the evidentiary hearings, I think it's good for the legal field that lawyers should be getting monies that are commensurate with the effort that is put in. And if we are looking to open the legal market, then should Indian lawyers not be paid or at the same level playing field as foreign lawyers would be?
Yeah. I don't see it as a bad thing, not at all. But what I'm trying to say is that, if you go in for litigation, how much are you saving? Probably nothing. You're just saving court fees. How much is the court fees? Why we come back to the same question. Why is this memorandum necessary? By driving parties to go to court and not go in for arbitration, you're not saving anything at all. Maybe a little bit here and there in terms of court fee or something. But if you're worried about expenditure, well, there are different ways of curbing the expenditure.
So, may I recommend one way is to actually flip the switch in a way that the government actually sees paying lawyers and arbitrators in the fees that is expended as actually developing the legal market in a phase-wise way?
Yeah, certainly. You're absolutely right. There's no doubt that our courts are overburdened.
So the memorandum states, and I'm going to quote for you, it says the reduced formality combined with the binding nature of decisions has often led to wrong decisions on facts and the improper application of the law. Do you think that this is simply a case of drafting having a rough day, or does it merit some concern?
It does, because again, the insinuation is that either the arbitrators are not competent or they are dishonest. Okay. Now, that's a very serious, sort of an allegation. Is there evidence for this? And if there are dishonest arbitrators, what has been done about them? Is it that, well, this person is dishonest, so therefore there's nothing we can do about it? If there are persons who are not competent, but they're arbitrators, why have they been appointed as arbitrators if they're not competent? And again, is something being done about it? What about training arbitrators? Okay. Just because a person is a retired judge or a retired chief engineer or retired something else, or even a lawyer, doesn't mean that the person is going to be an outstanding or a good arbitrator. So you need that, training. That's one. And the second thing is that, you have to keep a watch on what exactly is happening. To say that, listen, in this particular case, the facts were wrongly decided or the law was wrongly applied. But that happens in a court also.
Of course.
So you will have a situation where one court comes to a particular conclusion, but the appellate court, will reverse,
Absolutely.
and say that there's no basis for this fact or whatever.
Right.
So really, I don't see the point of, this statement in the memorandum.
So also at one level, we say we want India to become an international hub for arbitration. Yes. The other thing is that on domestic arbitration, you have the government, which is the largest litigator. And yet we are saying that don't trust our arbitrators. But somehow we want the international community to trust our arbitrators, bring their international arbitration to India. I mean, this is completely something which, we're speaking in two voices.
Yes.
How do you reconcile this?
Yeah, well, I find it difficult to reconcile this. The government so far has been encouraging arbitration. All right. And to say that India should be, an arbitration a hub for international arbitrations is something that the government has been talking about. Then on what basis do you say that, listen, we can't give you, competent arbitrators, we can't give you honest arbitrators, but nevertheless, come to India.
Come to India, yeah.
I don't think the business community will buy that.
Yeah, exactly. Yeah. So something that you had mentioned about trainings of arbitrators, and I was I wanted to talk to you about that, because if for a moment let's go with it that, or accept the government's position that indeed our arbitrators are corrupt and our arbitrators are not up to the world standard. Though I frankly myself don't agree with this narrative. But would the answer be to tarnish the community, to move away from arbitration, or to look at trainings?
Yeah, look at trainings.
Accreditation, for example.
Yeah, I think that's very important. Again, many years ago, Lord Mustill had come to India, and he was talking about training. And they train arbitrators. Why can't we do it? I know in matters of judicial education,
Yes, sir.
judges are trained on writing judgments.
Right.
So it's not that because you're an arbitrator, therefore you know how to write an award, you know how to conduct proceedings. Maybe you do, but there's also a possibility that you might make an error somewhere.
Right.
So training is absolutely important. I'm completely in favor of training.
So yeah, I've had the benefit of seeing the Tamil Nadu Judicial Academy, because we do trainings there on arbitration. But something on those lines for arbitrators, is this an initiative the judiciary could run?
I think they should. Yeah. Now, if you have arbitral tribunals that are fully trained, the number of mistakes that they will make will be very few.
Yes, sir.
All right. Now, if the number of mistakes they make are very few or perhaps none, the question of somebody going to court will not arise, or the court interfering with the award may not even
May not arise.
So, if you have trained arbitrators, yeah, it will certainly reduce the number of cases coming to the court under Section 34.
There has been an emphasis in the memorandum on mediation.
Yes.
But the sort of subtext of it is mediation and then court, as opposed to mediation and arbitration. Why can't that coexist?
Yeah, you see, my impression is that the memorandum is not clear. I mean, the person who drafted the memorandum is not clear about mediation. Mediation does not mean that the mediator suggests or imposes solutions. Both the parties who are, in the mediation process, they are the ones who find solutions.
Right.
The mediator facilitates them in finding solutions. And they are the ones who arrive at a settlement. So if they arrive at a settlement, which is obviously going to be acceptable to both, there is no question of going further.
Right.
Then you can't have an arbitration. There's no question of going to court also.
Exactly. So I think the confusion that appears to be is that mediation can be an alternative to arbitration, which is it's a contested proceeding, just like it is in court.
Yeah.
So I agree with you that maybe it's at least it's hope that it's a drafting error, and because mediation and arbitration can also coexist.
Yes, yes.
So who's going to constitute the high-level committee?
Well, if I remember correctly, I think the memorandum says it could be a retired judge, it could be officers, but the purpose of having a high-level committee is not very clear from the memorandum. If the idea of the high-level committee is to ensure that cases do not go to court, all right, there has to be some mechanism for them or some basis for them to come to that conclusion. You see now, for example, under the income tax department,
Yes,
or
sir.
the customs or the excise department, they have their own circular or procedure or whatever it is, which says that if the value of the dispute is less than a particular amount,
Right.
except the decision of the departmental authority or the
Okay.
tribunal.
Right, right.
Okay. If it is more than that, then you go to the High Court. If it is even more than that, then you go to the Supreme Court. So don't litigate unnecessarily.
Unnecessarily,
Okay.
right.
So in a situation like this, where you have the memorandum, You leave the ceiling of 10 crore aside. It is possible, either through the high level committee or through some, memorandum or circular or something, to say that, listen, if the award against the government is, say, 10 crores or less,
Right.
accept it. Okay, if it is more than 10 crores, but between 10 crores and 20 crores or 10 crores and 30 crores, go to the High Court. All right, if you lose in the High Court, accept it. But if it is more than 30 crores or more than 50 crores, whatever figure the
Right.
government decides, only then you go to the Supreme Court. Today, there is no such procedure. So even if the award is for a small amount,
Small value, they'll
yeah,
litigate it
they
right
will
up to the
litigate it
Supreme
right up to
Court.
the
Yes.
Supreme Court. So I think the purpose of that high level committee should be clear.
So, lastly, I want to know, is there a silver lining in this memorandum? Would litigants be forced to go to, for example, commercial court? And would that then lead to the development of jurisprudence in the area of damages or expert witnesses in the manner in which we seek discovery, for example?
Yes, it certainly can make a difference, but again, one has to be a little careful in the sense that the commercial courts shouldn't get clogged.
That is going to happen with the
You know,
number of disputes that are going to come.
yeah.
But in a utopian world.
In a utopian world, yes. I mean, of course, it's things like damages, discovery, and all that. The jurisprudence will develop. Certainly, there's no doubt about it. I would say that the government should make haste slowly. Look at it from a global perspective.
Perspective, yes.
You know, why have you come out with a memorandum like this? What is it that you want to achieve?
Yes.
If the idea is to have India into a hub for arbitration and for international arbitration, how do you go about it? Issuing a memorandum here or a memorandum there, these might be knee-jerk reactions. And in this particular case, it appears to be a knee-jerk sort of a reaction because there's no evidence to suggest, that arbitrators are incompetent or they're dishonest or things are going wrong.
So what would India need to get this utopian concept of making the commercial, all of the litigation go to commercial courts?
That's a tough question. For one, you have to be careful that
What you ask for.
what you ask for, right? Do you have commercial courts in an adequate number?
Yes.
It should not happen that judges who are in commercial courts should then be told, "Oh, you are dishonest," or "You are incompetent." So the whole thing has to be thought through. It's
Right.
it's like a package deal, not a little bit here, a little bit there. It's the whole thing.
So before I end, my wish list would have been in 2015 when the amendments came, was to make India into a global arbitration hub, bring a lot of business into India, and then also simultaneously uh, have a situation where foreign parties could opt to come to even commercial courts in India. I mean, it's too far-fetched to think about that, but when I think about the number of children that are coming out of law schools and the opportunities that we could have potentially created.
Yes, well, the idea was good in 2015,
Yes.
but to what extent has it been developed or implemented with that idea in mind? I think that's the question that we need to ask ourselves. If we have made mistakes, let's correct them.
Absolutely.
And look for the future.
Sir, thank you so much for being a part of our conversation today.
Thank you. Thank you.
This concludes today's episode of Navigating Commercial Disputes. Stay tuned for more in-depth discussions on legal issues that matter most.